Well, hello and welcome to On Second Street, where today we're going to be talking about our court system. Lately, it seems like there's been a number of stories about decisions handed down by judges that don't seem to be going over too well with the public. And someone who's been keeping a close eye on the judicial system is Jamie Sarkonak. She's a columnist with the National Post, and she joins us to talk today about some of the recent decisions that she's covered. Jamie, thanks for taking a few minutes to chat. I wonder if we could maybe start off with an Ontario Superior Court of Justice named Faisal Mirza. My apologies if I'm pronouncing his name wrong, but it sounds like he's on a bit of a crusade to have race included more in the sentences that are being handed down. Could you tell us a little bit about what you've discovered with this particular judge?
For sure, Colin. Well, he's an interesting fellow because he spent his career, and I would put that at about 20 years, advocating for more racial considerations in the criminal justice system. One of those things is racial considerations in sentencing, and that was a big thing he was pushing for as a criminal defense lawyer. Into the early 2020s, he was making reports for his clients and saying, my client is black, and so what the court should do is take into account the his life history, basically, and various things that have affected him that relate to systemic racism. So he would get a report written up about his client, and then he set up actually some sort of, I believe it was a nonprofit, but a different group that would do this for other clients of other people as a service. And he would submit this to the court upon sentencing, and it would be up to the judge to take these factors into account. And what he managed to do,
Hmm.
I believe in 2022 or 2021, was get the court to say, yeah, let's make this part of our sentencing regime across the board in Ontario. So they started allowing defense lawyers to submit what are called impact of race and culture assessments as part of
Hmm.
sentencing for clients who aren't white. And those sort of background factors, anything that a report writer can come up with, whether it be this person was called racist names in school, or maybe they just grew up in poverty and the report writer links that to racism, that kind of background would be taken into account for the person who is being sentenced. And so the rule is, in Ontario at least, that that judges can or should take off time in a person's sentence if their moral culpability or lack thereof can be connected to systemic racism in their past. And often they do find that it can be connected. So it amounts to a racial discount, is what it is.
Don't we want a court system that is blind of someone's race and instead focuses in on maybe, let's say, if you are going to reduce a sentence, shouldn't it be because maybe they were abused or they had a tough upbringing or whatever, regardless of race? Why would you only say certain races would get this discount?
Well, exactly. And that's sort of the common sense perspective. And courts already take
Hmm.
those into account when they're sentencing any individual. Did this person have a learning disability growing up? Did this person, were they a victim of abuse growing up? And whether that should be taken into account is a different question, but that was already what was happening in general in sentencing. But with
Hmm.
the advent of the BLM movement and just talk of what systemic racism is in general, this became an extra point. They wanted to go above and beyond to show that the courts are taking this into account. They're taking systemic racism into account. So they wanted to be extra clear that this was going to be a factor in sentencing. So yeah, is it extra? Is it necessary? I would say yes, it's extra, and no, it's not necessary, because we should already be taking
Hmm.
those tough background factors into account. But this is an extra thing on top of that. So it amounts to being an unfair justice system because these considerations aren't being taken into account for, say, a white guy who grew up in a trailer park with crime all around him. Well, he's white. He doesn't get that.
Yeah.
Sorry.
Yeah. Yeah, it seems very odd that we're seeing this push because, like you said, it's you're creating rules based on race, which it seems to defy what the court system has traditionally tried to do. We're going to continue to talk about different judges' decisions in a moment. We have to take a commercial break. And we're back on Second Street, where we're talking about a number of recent judicial decisions here in Canada. We're talking with Jamie Sarkonak from the National Post. Jamie, I want to just ask you about something that's come up recently. I mean, we're just talking about this decision or this sort of push by the Ontario Judge Faisal Mirza, who you profiled in a recent column, and then coincidentally, not long afterwards, the Ontario Bar Association put out a column or a news release where they didn't indicate the column or the columnist, but it seems like they're talking about you, where they include in their news release, quote, they're warning the media on the dangers of delegitimizing judges. And it seems like they're taking exception with that column of yours. I find this strange because as much as a columnist may critique a judge's decisions, you can't remove the judge from office. At least you certainly don't have that power. Um, so what on earth are they talking about here when they say that people are delegitimizing judges?
Yeah, well, one, they're ignoring the open court principle, which is just the idea that the public can engage with what's going on in the courts and criticize what's going on in the courts. Of course, the public can hold elected representatives to account, but really our only recourse with the courts is talking about it because we can't remove judges from office in an election.
Yeah.
Judges are appointed. So that's one point. Another one is that the Canadian Bar Association in their statement said that um, what happens in a judge's career before they get named to the bench is separate, and we shouldn't confuse that with what their decisions are afterwards. That's interesting because when other judges have been named in the past to the bench, and progressive institutions have taken issue with whatever thing they've done because they violated some tenet of the left. So it has gone both ways. One, two, why not look at a person's career prior to going on the bench? Because clearly that informed the decision of whoever appointed them to appoint them. The idea
Mm-hmm.
being you're now going to make informed decisions on the bench informed of those perspectives. So when someone like Faisal Mirza is appointed to the Superior Court of Ontario, that does send a message as to what is expected. What are we trying to get out of the bench here? What kind of people are we putting on? What is their thinking when they're making decisions? So it's totally in scope, and the Canadian Bar Association, interestingly, just dropped all of that and said that no, you shan't critique their previous career. You can't look at their career and then look at their decisions and draw any line between those. That's totally inappropriate. It seemed that the presumption was, according to the Canadian Bar Association, that whatever a judge says is sacred and we can't talk about it and we can't take issue with it.
Well, with all due respect to them, I think judges deserve to be accountable like everyone else in society. We should be looking at their decisions, what their values are beforehand, and so forth. So that's why we're doing this episode. But let's talk about another judge now. Justice Jane Kelly, Ontario Superior Court judge. You wrote about a story that she was involved in recently, where a Jamaican Canadian woman, sadly, she left her toddler alone in the bathtub. It's a toddler, 15-month-old son, and he drowned. And they somehow, out of this, pulled in systemic racism into the sentencing for or the decision for her particular case. Could you tell us a little bit more about that story?
Yeah, so it wasn't just that the Jamaican woman left her son in the bathtub. She actually put headphones on, went off to do house cleaning for 10 minutes, and then closed the door so that it was just ajar. So she really seemed to isolate herself from what was going on in the bathtub. So it's a hair above an accident. It looks pretty bad. Um,
Yeah.
but you're right. Systemic racism was taken into account when deciding on the sentence. It was a jail sentence. I think it was 9 months. I could be wrong. I could be confusing that with another one in my head. But I remember seeing the sentence and comparing it to some other ones about infant neglect leading to their death. And it was within the range of that's how they get sentenced. This judge, I don't
Hmm.
think, had a history of activism. I didn't look too deeply into that, but she did not raise any red flags. So it appeared to be, for the most part, fair, but the whole sentence was undermined by the fact that she had to take systemic racism into account. And she delineated that exactly in her decision, in part because of that, in that Ontario rule that they have to take systemic racism into account if they can connect it to the offense and the conduct of the individual. So yeah, it just doesn't look fair, because you look at it and you know that if a different person who was white was in that situation, they would have gotten more.
Yeah. Okay. I want to ask you a little bit more about this case. We'll be back after this commercial break. And we're back on Second Street talking about different decisions being handed down by judges here in Canada. Jamie, we're talking about this case from Ontario where this particular judge included systemic racism in her decision that she handed down, and you had mentioned that that's kind of protocol. Is that something that the judge has to take into account by law now, or is it that it's an option that they can take into account?
Well, a judge who really stands for this stuff would say that it's an option, it's not a racial discount, there is a way to not apply it. But for the most
Hmm.
part, it is a rule, because the rule is, if you can connect the person's background factors, their experience of racism as a child, their experience of poverty, which people who believe in systemic racism just draw a straight line. They say the poverty is because of systemic racism, obviously. So all of that gets,
Hmm.
um, I guess, scooped into the same stew of reasons behind this person's moral failure that brought them
Right.
before the court. So if you can draw a connection between all of that background and the conduct that got them before the court in the first place, then you have to take it into account. You have to somehow factor that into the sentence. So that usually ends up being applied. Like it's a very easy threshold to meet, so easy that we should call it a racial discount because it accurately describes what it is. There is the odd time where it's not
Yeah.
taken into account. That's true, but again, that threshold is so low and that requirement is there that they have to at least consider it. Because if they don't even consider whether it should apply, that is a legal error and they can get appealed up. So, yeah, they do have to really
Right. Right.
delve into it. Yeah.
Hmm. I kind of wonder, across Canada, we find these statues outside of judges or outside of courthouses where they call it Lady Justice, right? It's the statue of a woman with a blindfold and she's holding the scales of justice with a sword. And it's to convey this idea that the courts are neutral and impartial. They're not taking into account sort of those personal characteristics of people when their cases are presented. Feels almost like we need to amend those to have the Lady Justice pulling up the blindfold, because that seems to be what's going on, isn't it?
Yeah, and that's what legal progressives would say needs to happen, because they would say that the courts themselves
Mm,
are systemically racist, colonialist institutions that disproportionately
mm,
and just by the force of unconscious bias punish people who aren't white harsher than people who are white, and therefore this needs to be factored in to balance the scales. They say that that is literally justice.
mm.
And then when you call them on it and say
Oh,
that's
really?
discrimination, they say, oh, no, it's not. So
No-win scenario. Let's jump into the next case. Chief Justice Wagner with the Supreme Court. You wrote an interesting story recently about the existence of Canada's border discrimination, or perhaps not, is what he wants when it comes to social programs. Could you tell us a little bit about that, Colin?
yeah, so recently the Supreme Court decided a case called Canada, and it was, in short, a majority of the court decided to extend daycare, Quebec's daycare program, to asylum claimants. And that means
Mhm.
people who have applied for refugee status in Canada but are still waiting for it. And so they haven't been vetted. We don't even know what their deal is. They could have just shown up one day and checked a box and said, I want to be a refugee here. And they're still waiting for the rest of the paperwork to go through and the processing. So they could be rejected. And so Quebec's daycare program is really broad and provides free daycare, or subsidized daycare, sorry, to citizens, to work permit holders, but it didn't give it to these asylum applicants. And this Supreme Court decision said that that is unconstitutional, that is discrimination. You must also extend that program to them. Um, in a dissent, so Chief Justice Wagner was not writing that binding decision, but he went further and said that um, any he wanted asylum claimants to be their own class of discrimination. So in the charter, it says you can't be discriminated against because of gender, race, religion, etc., creed. He wants to add in through Supreme Court decision a new ground of
Hmm.
discrimination equal to those that would be just asylum claimants. He's saying that it's a immutable characteristic that needs protection. So that's not the law, but it is concerning to see the Chief Justice say something like that.
Yeah, it is a surprising one. It seems like it could open up a huge can of worms. I want to chat with you about that in a moment. We'll be back after this commercial break. And we're back on Second Street, where we're talking about a number of recent judicial decisions and actions by judges. We're chatting with Jamie Sarkonak, who's a columnist with the National Post. So, Jamie, before the break, we talked about this recent dissenting opinion expressed by Chief Justice Wagner on the Supreme Court, where, and I'll use layman's terms here, it sounds like he wants social programs to be available to asylum claimants or asylum seekers in Canada, even before they're accepted as Canadians, as asylum claimants, whatever. Is that really what's going on? And what is the potential for this decision to really explode into all kinds of other services being provided to people who aren't really Canadian citizens?
There's a huge risk with that last bit happening. So, what Chief Justice Wagner said was the asylum claimant status should be equal to race, religion, gender, creed, which means it should get
Hmm.
that kind of equal protection. Um, there has been a lot of litigation about what the charter right to equality means and what you can and can't do with respect to sex, gender, race, religion, etc. And so, if you were to add asylum claimants as a category like that, you would have to do that same mental exercise with them. And you can't um,
Hmm.
get very far in that without seeing how suddenly asylum claimants might just become eligible for free healthcare across the board. Suddenly, that choice to offer services to asylum claimants is no longer a choice that provinces and the federal government can make. It's a court required thing that you have to do. I start to wonder, where does the right to vote start coming in if we're going to say that you can't deny someone equality on the basis of being an asylum seeker? Why shouldn't they have access to participating in our elections? Because they're here by the same logic that we extend the vote to women, you could extend it to asylum claimants under this bizarre logic. I mean,
Yeah.
that's how radical this kind of thinking is.
Yeah, it feels odd. I mean, you mentioned healthcare. That's what comes to my mind. I mean, you're probably not going to try and get a hip operation by jumping over the border because the wait time would be so long. But maybe if you're having heart problems, you dip into Canada for a few days and say, I'm an asylum claimant. In the meantime, go to an ER and try and get some kind of heart operation or something like that. It feels like it would be a real slippery slope. I mean, you mentioned voting too. That would be concern too. I mean, overall, it seems like when I look at your work, I'm noticing a pattern of decisions by judges that I would guess are out of step with what everyday Canadians would expect in terms of, uh, the values that should be behind those decisions. I want to ask you, is that sort of your take as you're going through these, or do you think that these are anecdotal cases? How big is this problem from where you stand?
Well, one, it's interesting that we don't have the statistics. My understanding is courts have been very cagey with releasing data about stuff they do. So it is hard to actually quantify, what is the average sentence for whatever crime. That would be very informative and helpful to have, but we don't have that. Um, but it does in general seem like a number of decisions are coming out that are just totally out of step with what I would say is public morality. We believe that
Mhm.
child sex offenses should be taken seriously. We we believe that generally race shouldn't be a factor in sentencing. If you ask the average Canadian that, they would just say, "What are you talking about?" That's what judges are doing now. So yeah, I would say it's getting out of step. There are of course many good judges out there who are trying to be as conservative as possible in applying these race-based rules that are being handed down to them by higher courts. But
Mhm.
it's very difficult to get around that when judges in higher courts are ordering you to do all this.
Yeah. No, that's a good point. I mean, I can understand if their hands are being tied, then it makes it tougher for them and they don't have that latitude. But um,
Mhm.
in closing, thank you for your time today and for doing what you're doing. I think it's important work. And again, look forward to hopefully having you on the show again.
Thanks for having me.
I'd love to hear your thoughts on this topic. What do you think about the judges we have in Canada? Are they largely on the right track and these are just a couple isolated cases, or do we have a bigger problem? You can send us an email at ideas@thenewsforum.ca. Thanks for watching, and hopefully we'll see you again next week.